Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The Supreme Court has today clarified that if an accused person while in custody for a case under the PMLA makes a statement to the Enforcement Directorate officers that incriminates him in a different money laundering case, that statement cannot be used as evidence in court. A bench comprising Justices B.R. Gavai and K.V. Vishwanathan was dealing with a bail application in a money laundering case. The bail was granted considering the long incarceration of the petitioner and the delay in trial due to large number of witnesses. The bench noted while the accused was under custody in connection with one ECIR, his statements were recorded by ED officers in connection with the present ECIR. The bench noted that the Supreme Court in Vijay Madan Lal Chaudhary versus Union of India in 2022 had held that statements recorded by ED officers under Section 50 of PMLA can be used as evidence in court. However, whether the protection under Section 25 of Evidence Act, which prevents confessions made to police from being used as evidence, applies to those facing charges under the PMLA has to be decided on a case-to-case basis. The court clarified that such statements cannot be used as evidence against the accused because when a person is in custody and being questioned by the same agency, they might not be speaking freely or voluntarily. Using such a statement as evidence would be unfair and go against principles of justice and fair play. Another significant observation by the court was that even under the Prevention of Money Laundering Act, bail is the rule and jail is the exception. The bench held that Section 45 of PMLA only lays down that grant of bail would be subject to the twin conditions and does not alter the fundamental principle that bail is the rule. The contempt case in the Supreme Court against the Delhi Development Authority over tree felling will now be heard by a bench led by the Chief Justice of India instead of the bench led by Justice Abhay S. Oak. For those of you who have been following this case are aware that it was heard on several days in June and July by a bench comprising Justices Abhay S. Oak and Ujjal Bhuya, during which the DDA and its vice chairman had to face several tough questions from the bench. During the hearings, the bench had observed that the materials indicated the role of Delhi Lieutenant Governor V.K. Saxena, who happens to be chairman of the DDA, in ordering the tree felling in Delhi's rich forest. The bench had also minced no words in pulling up the DDA for cover-ups. At the last hearing, that is on 12th July, the bench had warned that it would issue contempt notice to the LG. Meanwhile, on 24th July, another bench led by Justice B.R. Gavai took objection to Justice Oak's bench taking up the contempt petition. Justice Gavai observed that his bench had issued notice to the DDA on a contempt petition filed by another petitioner with respect to the same tree felling much before Justice Oak's bench initiated the proceedings. The bench led by Justice Gavai, noticing the parallel proceedings, had referred the matter to the Chief Justice of India. The matter is now listed tomorrow before the bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra. Stay tuned. The Calcutta High Court today dismissed a PIL seeking to modify a judge's roster due to allegations of conflict of interest. The court also imposed an exemplary cost of 50,000. Also, the litigant, a lawyer by profession, has been debarred from filing a PIL ever again. Advocate Sanjoy Das, the petitioner in this case, requested a change in judge assigned to hear cases related to police inaction, specifically Justice Amrita Sinha. He argued that because the West Bengal CID was investigating Justice Sinha's husband for allegedly using her position to influence an investigation, it could create a perception of bias. As a result, he claimed that her continued involvement in cases related to police matters might undermine public confidence in the judicial system. For your understanding, let me tell you that the Chief Justice of a High Court is responsible for deciding the roster, which determines the allocation of cases to different judges within that court. This authority is part of the Chief Justice's role as the master of the roster. The Chief Justice decides which judges will hear which type of cases based on factors like the judge's expertise, experience, and the nature of the cases. Hearing the plea of the petitioner in this case, a division bench of Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya stated that the Chief Justice has the exclusive right to decide which judge hears which cases, and this decision cannot be challenged by a petitioner, especially not by a lawyer practicing in the court. The court viewed the petition as a misuse of the legal process, possibly intended to intimidate the office of the Chief Justice. Interestingly, the next matter on the cause list, which was filed by the same litigant, was also dismissed as non-maintainable by virtue of this order. In the second petition, the same petitioner had challenged a 12-hour strike called by Bharatiya Janata Party to protest police action against protesters who were marching towards the Nabana State Secretariat building in connection with the brutal rape and murder of a resident doctor at RG Hospital. The Supreme Court has today issued a show cause notice for contempt action to Rajesh Kumar, Additional Chief Secretary, Revenue and Forest Department, Maharashtra Government. This was after the court took exception to certain statements in an affidavit filed by him, which suggested that the court was not following the law. Observing that the statements were prima facie contemptuous, the court directed him to remain personally present before the court on 9th September. The bench of Justices B.R. Gavai and K.V. Vishwanathan was hearing the matter, wherein it had directed the state of Maharashtra to provide reasonable compensation to applicants whose land the state had occupied illegally. Previously, if you remember, the Supreme Court told the state of Maharashtra that while the state had money to waste on freebies, there was no money to provide compensation. It had warned that if the state did not think carefully before making decisions, it would order the state to pay compensation under the new law and might also stop all the state's freebie programs. The main application here was filed by a man for compensation after the state took land from his predecessors in 1963, with the dispute reaching the Supreme Court and the land later given to a defense institute. Today, the State's Council informed the court that 24 acres of land within Pune Municipal Corporation could be allotted to the applicant from the state's 14-hectare land. The court asked the applicant to choose between the land or compensation and scheduled an inspection of the site for 30th August. The Karnataka High Court has dismissed the petition filed by Special Investigation Team seeking cancellation of bail granted to Janata Dal secular leader H.D. Revanna, who is accused of abducting a woman. Revanna was granted bail by the special court in May. The SIT had submitted that obscene videos allegedly involving Prajwal Revanna with the woman prompted the victim's son to lodge a complaint. It is alleged even before the complaint was lodged, the woman was abducted and an attempt was made to silence her and to destroy the evidence to ensure that she did not lodge a complaint. On the other hand, senior advocate C.V. Nagesh, appearing for Revanna, argued that the only evidence against him was a statement from co-accused Satish Babana, which mentioned Revanna asking someone to bring a lady to his house. He had also argued that kidnapping was not applicable in this case because the victim was an adult and not a minor, and that there was no established demand or threat in this case. A single judge bench of Justice M. Nagprasanna had reserved the order on 1st August after hearing the parties. The High Court today refused to cancel Revanna's bail and also granted bail to Satish Babana and others who are co-accused in the case. The Karnataka High Court, by way of interim relief, has stayed the defamation proceedings initiated against Spunk Lane Media Private Limited, which owns and runs the news portal The News Minute. The defamation case was regarding an article published by The News Minute in May 2021 titled, "Yet Another BJP COVID-19 Controversy in Bengaluru, MLA Accused of Blocking Vaccines." The suit was filed in 2022 by BJP leader L.A. Ravi Subramanya, seeking damages to the tune of 3 crore against various persons including media houses for the tweets and articles published. The company appeared before the trial court and contended that the BJP MLA disclosed no cause of action and that the case was liable to be rejected. When the trial court refused to grant any relief, it approached the High Court. Before the High Court also, it argued that Subramanya had nowhere in the plaint set out the alleged defamatory works in any of the articles published, nor explained the defamatory nature of the articles. The court granting interim relief has stayed further proceedings till the final disposal of the petition. The matter will next be taken up for hearing on 10th September. And lastly, the Delhi High Court has today directed the union government to treat as representation a petition filed against exclusion of provisions similar to Section 377 of now repealed Indian Penal Code from the Bharatiya Nyaya Sanhita. The police sought restoration of legal protection against non-consensual sexual acts equivalent to those provided under this Section 377 of IPC. This is to ensure safety and dignity of individuals, particularly those belonging to the LGBTQIA+ community. Acting Chief Justice Manmohan and Justice Tushar Rao Gadela directed the central government to decide the representation expeditiously, preferably within 6 months. The court said that the provision will have to be introduced in the BNS in a new form, and the same has to be done with consensus from all the parties. The court also said that the issue not only deals with the state, but is also against public at large. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.